In this video, I'll discuss briefly the legal requirement of divorce and the procedure in UK legal system for divorce application. As you know, divorce many people find is very difficult and stressful, whether it should apply or what is the requirement, whether if my husband or if my wife doesn't give consent or not assist or cooperate, will the court pronounce an order? So these all questions will you may get your answer, and including the finance, the claim against your other half for property or anything, very briefly within a couple of minutes. And please stay with me. Viewers, my name is Sohan Ahmed. I'm a solicitor. If you need any assistance, please feel free to contact with my office, give a ring, and make an appointment. I'll try to give or assist you. So, first of all, if you want to give divorce, then first question what you need to know is whether you are eligible to give divorce. There is although the divorce law has changed last year, but still there are some requirements, which is first of all 1 year rule that you must be relationship must be last for at least 1 year. And the other requirement is your marriage is legally recognized in the UK. So if you get married anywhere in the world, if it is a valid marriage according to legal marriage, according to the law of your country, you can recognize this marriage. Therefore, it is accepted. You can divorce in the UK. So whether it is irrelevant whether you get married, as soon as you recognize the legal marriage in your country, you can recognize this law. Therefore, you can get divorced in the UK. The other last requirement is your relationship has permanently broken down. So this is the main grounds currently for divorce. Now, in terms of the main issue, what is people are facing, or they're thinking that if I make an application, if my husband or my wife doesn't give consent, will the court or will I able to get it done? Yes, even though if your husband or your wife doesn't give consent to divorce, as soon as you satisfy this requirement, you can proceed with the divorce without the consent of other party. What you need to do when you apply for divorce, you have a couple of issues, a couple of ways you can do it. First, once you submit the petition, then you can apply to the court for a bailiff service. So you can call to the court, send a copy of divorce application and acknowledgement of service D10 to you, and you can serve it personally by yourself or by a relative, by anyone, or by bailiff, or whatever way. This is the one option. And then you can tell the court, I have served the bailiff that the respondent hasn't submitted the acknowledgement within 7 days. Then you can ask the court to make a decision on one party basis, or team service, which is called. The other option is whether the respondent even not cooperate, or they are not responding. In that case, also you can apply for a conditional order, which is second stage, decree nisi, because divorce in your three application, you made first petition, then decree nisi, and then decree absolute. So in that case, you can apply for second stage, even though the other party respondent hasn't acknowledged it, but still you can make an application to the court for conditional order. But what you need to do is you need to complete section B of application for conditional order or decree nisi, and you can ask the court for a case management conference. And in that case, court will fix the hearing date. You can attend personally and explain to the judge the situation. There's I have served by post or by email, or if you haven't served, but respondent is not cooperating me, but I want to give divorce. Court will grant your application if it is appropriate. So this is the way where other party not cooperating or not confirm the court that I received the petition. Still, you can go ahead with your divorce petition. Now I'll give you a bit what actually was before. Divorce law is more flexible. Now you don't need to blame each other. So that has the very significant changes in divorce law. Before there are 5 solid issues where you need to identify which is applicable to you, whether it's a domestic violence, unreasonable behavior, adultery, 2-year separation, 5-year separation. This was the complexity or concern by other party. But now you don't need to rely any of these facts. This is 5 facts is no more relevant for your divorce application. Divorce application now you can make by sole application, which is by yourself only, or by agreement of both parties. So as I discussed, if you make application by just yourself as your wish, you can go ahead with all these states, satisfy all this requirement, and then finally decree absolute. If both parties agree, yes, it is more easier. What the difference? Basically, if both parties agree on divorce, then it's more quickly the court can end this matter and you can complete the decree absolute. But if both parties not in a cooperative with each other, then it's little bit delay. That is the complexity. Otherwise, that's fine. Still, court will accept your divorce application if you satisfy the requirement that is the relationship has broken down as soon as you satisfy the court. So the court fee is 595 online application court fee. But if you don't have money to pay the court fee, you can fill up an online form which will help with the court fee, and you can get a code. And if you give this code on the application form, it will go through. You don't need to pay any court fee. So it's free of charge. You can submit your court divorce petition to the court online. The best way you can do it. Now, the question is, should I go to a solicitor? Well, this question is, first of all, it's a divorce application. If it is just divorce, if you have ability to do it, I appreciate do by yourself. But certain circumstance, what I recommend, you shouldn't make a decision by yourself. You should go to a solicitor where you are claiming finance, you are claiming maintenance for yourself, you are claiming maintenance for children, you're claiming finance for you for the family, where there is a potential division of the family property where you live. So all this stuff, when there exists, if you think that there is a potential claim, a financial remedy application you need to make in future, in that case, my recommendation is you should consult with a solicitor, because there are lots of loopholes where the party should get legal advice, especially in the division of property, because most of the couple have a saving, income, pension, share, capitals, income, capital, property. These are the sort of area where you need advice and how to proceed with division. So that's what you need to discuss with the lawyer before that. But the concept is another one, what especially for those foreign nationals who are settled in the UK now, but they have some property in back home, and always the other party try to hide this property which is back home. But under the Matrimonial Cause Act 1971, the property wherever situated still is within the definition of matrimonial property, and you can claim it. If you are settled in the UK, if you don't have any connection in that country, you can speak to a lawyer and they will advise you how you can get information. But when you go to the financial remedy proceedings, there is a lot of direction. Court will, their solicitor will raise this issue to other party, and this is how you can get this information. But this is a different part. What I want to tell you is that if you have a financial issue in your divorce application, if you have a claim against your ex or your current husband, then you should go to a solicitor. Even if you need advice, I think at least you do a consultation to a lawyer, whether you should go divorce, what the procedure, what the legal requirement, whether you are eligible, and what you should do. That will give you a brief idea actually to make a decision rather than depend on you. Maybe you'll pay a consultation fee, but it is worth to pay a couple of quid to someone to get a legal advice. Now, financial remedy application, this is a separate part, but it also I think is a sister of is a half sister of divorce, because financial remedy application will go through the divorce. When you make the divorce application, same time, anytime, either decree absolute, before the decree absolute, or after the decree absolute, you can make this application. But there is a legal issue where you have to be very careful. If you want to make a financial remedy application, make it before decree absolute, because after decree absolute there is some obstacle. For example, there is an issue for remarriage by the other party. There is an issue of claim maintenance for yourself. So all these issues which you can claim after you decree absolute. Therefore, my suggestion is, if you have a plan to make a claim for financial remedy, then you should make this application before decree absolute. So this is a brief application, brief video what is the legal requirement, what you need to know about divorce. So now you can make a divorce application by yourself only without get consent from the other party. You can proceed with all step 3 stage petition, decree nisa, and decree absolute go through without blaming each other. I hope this information will help you. If you need any help, please feel free to contact us.